moving on to discovery and pretrial motions. Not going to spend too much time on discovery. I'm kind of going to go through this pretty quickly. The discovery rules are things that you can read about and can look up online. There's not so much nuances to it. We'll talk mostly about the nuances. Federal Rule of Criminal Procedure 16, 26.2, and 18 U.S.C. 3500, which is the Jencks Act. That's the really nuanced one. Brady versus Maryland, same as state court, requiring any and all exculpatory, inculpatory, or inculpatory information to be turned over. Brady and Giglio requiring those. And we'll talk about Federal Rule of Evidence 404B, which is a pain in the butt. Practice tip, try to negotiate with prosecutors to get discovery disclosures as early on as possible. Set timetables out when you're going to be getting those disclosures. It also helps. You can ask the prosecutor if they can send a letter attached to the disclosure explaining the discovery. It saves some time. And know these rules above really well, and definitely know your local rules as it relates to discovery. So practice tip, demand discovery at initial appearance arraignment if your district allows it. Most of them do. Sometimes you don't even have to ask for it at the initial appearance, or if charges have been filed, more likely at arraignment, the government will issue a standing discovery order. And this is an example of what a standing discovery order looks like here that you can review. How discovery is produced varies by jurisdiction as well as the case. Sometimes it's hard documents we get in the mail. Sometimes it's hard. We have to provide a hard drive depending on the district, how much discovery it is. In a healthcare fraud case I have right now, it's over 7 million documents, so it's a big hard drive. DVDs, cases involving sensitive information or vulnerable witnesses, you have to sometimes do what's called an evidence view, similar to state court. That's very common in child pornography cases, of course, where the evidence can't be disclosed to you. It has to be viewed at the FBI's office. And so you're going to want to have to go there if you take on those cases. We have many of them and they're tough, but that you're going to have to go see in person. Be prepared to have a document review system in place, at least a Dropbox if you're doing financial crime, which can involve hundreds of thousands or millions of documents. See if the prosecutor will create a hot docs, they call it, which is kind of a way of getting an early exhibit list. It's usually going to be, if in a big case, around 500 to 2,000 of the most pertinent documents, so you can at least get started with your client on those. But you're definitely going to want to have a system in place for sharing those documents and managing them. Quick note regarding discovery and federal, huge difference. You're not getting depositions. Rarest circumstances, but do not expect to ever get a deposition on a federal case. And that's part of the reason why so many cases resolve. Just a bit about Brady Giglio requirements, disclosure of exculpatory and impeachment evidence. Rule 16, familiarize yourself very well with Federal Rule 16. These are all these things here, what the government must disclose, statements by employees, relevant oral statements. Just for time's sake, I'll just have you go through that yourself, familiarize yourself with it. There's nothing too nuanced about it. But it is important to note that it does not authorize the disclosure of reports, memoranda, and other internal government documents made by an attorney for the government or other government agent in connection with investigating or prosecuting the case, so basically work product. So Jencks Act. Jencks Act is a very nuanced one. So under the Jencks Act, the government must produce the prior statement of a government witness only after the witness testifies on direct examination. for a while, that was only at trial. Now it applies to suppression hearings, habeas corpus, or other forms of post-conviction or interlocutory appeals type of situation. Rule 26.2 basically took the Jencks Act and said it applies to things beyond trial, sentencing hearings as well, preliminary detention hearings. This is really difficult. In federal trials, in state court, you get everything. You get any report that the law enforcement officer issued, things along those lines. You basically get their work product, supplemental reports. In a federal case, you might not, and very often won't get the report that the witness for the government is testifying about or relying on until after they're direct. You can imagine it makes cross-examination quite tedious. You have to be prepared for it. The federal trial is not easy, and Jencks is one of the main reasons for that, is because you're not getting some of your most necessary discovery to prepare for cross-examination, to prepare to impeach them with documents, the government's witnesses, until after they've already testified. Most federal trials, you're spending the night after the trial going through the Jencks material that was turned over that day. File motions to compel and just try and get as much as possible from the prosecutor. So 404B is basically the equivalent of other bad acts or Williams rule in state court. Very difficult. Do your best to find out if it is going to be coming in, because it can come in really at any time, and in reasonable advance of trial can be a week. And this is them bringing in other bad acts that they can use against your client. You have to be prepared to file motions to eliminate 404B evidence. It's one of the strongest tools that the government has. And ask them early on if they expect 404B, because that definitely is a big factor in whether you're going to try and resolve via plea or go to trial. Pretrial motions, very similar to state court. These can include motions to dismiss charges, suppress evidence, bill of particulars, motions to strike, motions in limine. Most important nuance here that I would advise for our purposes is Rule 12 lays out exactly, Federal Rule 12 lays out what the motions are, but consult your local rules. Don't file a motion, Adam said earlier, and go in and have a judge say, this is 11 pages. This type of motion in my district requires 10. Not a great look, especially for an early practitioner. Consult your local rules. If it's not clear in the local rules, consult somebody in your district, a colleague, or I'll help if it's in my district.